Many people do not have a will in place to dole out their property after they die. Some farmers write their own wills so that the state won't get their land, but some tax experts say this probably isn't the best idea. Well, joining us right now is Roger McEowen with the Washburn School of Law, and he talks about some of the guidance in today's Rule Money segment here on the Market Day Report. Good morning, Counselor. Welcome. Let's start with some of the basic legal requirements for a valid will. What are they?
Well, good morning, John. Good to be with you. Well, they vary from state to state. Every state has a list of statutory requirements that you have to satisfy in order to have a will recognized as valid in that particular state. For example, every state says that a person that makes a will has to be of sound mind. So, John, I don't know, I hope you have a will in place in case there's any question about that. But that doesn't mean you have to pass any type of intellectual test. That just means you can identify your property and your close family members and know who your relatives are and how your property generally is going to pass into your will. Then you're deemed to be competent to write a will. If you don't have that trait, then the will can be attacked for you having lacked testamentary capacity. That's the big requirement. And then, of course, there are witnessing and signature requirements and those types of things.
So, Roger, what do farmers need to keep in mind when it comes to a handwritten will then?
Well, I get that question not infrequently, and the answer is that you can write your will. Just about every state will recognize a handwritten will as a valid will. We call it a non-cupative will. But there are certain requirements that it has to satisfy. It has to clearly express your intent to dispose of your property. We don't want to have language in there that we call precatory language that says, that it's my desire and I've got these concerns and so forth. You need to be specific about leaving your property items. And then there may be some other statutory requirements for a handwritten will, such as a signature and witnesses and a date on it. But other than that, you can write your will.
So would you advise farmers to write their own will, Roger?
Well, that answer kind of depends. I wouldn't explicitly advise anyone, if you want to have a will, to do it yourself because you can run into trouble. There was a recent North Dakota case that really shows that trouble, and I wrote about that in a recent blog post. You can use terms that mean different things, such as a parcel of land and you don't identify it, or again, as I said, you're just expressing desires and wishes and you're not specifically disposing of your property. So you have to be careful on that. If you've got any type of substantial property, the answer would be no. Don't risk it, and don't risk any type of challenge to it. So in general, yeah, you can do it. Is it a good idea? Probably not in most situations.
Well, Counselor, we always appreciate you joining us here on the program. Always good to talk to you. Roger McEowen with the Washburn School of Law in Topeka, Kansas, joining us here on the Market Day Report.